LexTalk.World, organized by Clickaway creators. Today we have a very special guest with us. He was the first solicitor born outside of Europe to start a law firm in the 1 square mile district of London in 1982. He has been named in GQ UK's 100 Most Connected Men in 2016. He's a former member of the International Court of Arbitration of the ICC Paris 1990. In 2002, the Indian Prime Minister awarded him for his outstanding contribution to the field of international arbitration law. Please welcome Mr. Sarosh Zaiwalla from Zaiwalla&Co. Welcome, Mr. Zaiwalla. We are honored to have you with us today.
It's equally my honor to be invited here to speak.
Thank you
and
so much.
I'm very happy to share my experience with you. Although I have lived in England for many years, I am very much an Indian at heart.
Well, that is just great to hear. So to start with, may I request you to give us a brief about your personal and professional journey?
Very good. I come from Bombay. I went to St Xaviers High School in Bombay.
Wow.
And I went to government in Bombay. And then I decided to qualify as a solicitor because my father was an English solicitor. And he was the youngest in his family. And so I went down to England with 60 pounds in my pocket with just two people. One, a colleague of mine at the law college, Marazman Patrawala, who sadly passed away after he became a minister in the Maharashtra government. And I have a brother's friend. And it was a great experience to start. And I've always thought to be that I must do things myself, and that's what I have always done. Well, then after that, I had to do 2 years of training with an English solicitor's firm. I did that. Then I decided I'm going to start on my own and not join a big English firm because those were different days. The British people were not yet used to somebody from India. And therefore, a very, very eminent arbitrator, Cedric Barclay, told me, he and I became friends. He was like a mentor. And he said, Sarosh, you're good, but when you qualify, start on your own. Because if you join a big firm, I said, you're good, they'll take you on. But every year, the senior partner will take you for lunch and say, good job, old boy. And this will happen every year. And people around you will be promoted, but you will remain there. So that's how I started. It was a risk. I started in one room at 29 Museum Street. I was also lucky. By chance, I met the Hinduja brothers, Gopi and Sri Hinduja, at an event. And they were obviously liked me and impressed me. So they just come from Iran. They had a very small office. So they said, he wanted me to join them. And I said, no, I'm not qualified yet. So I said, there's no question of joining. But fortunately, I managed to have an agreement with Stockin & Company where I was training. And they allowed me to work, have an evening job from 6 to 9 at the Hinduja, Sangam Limited. There were just 4 or 5 of us. So it was a great experience because they were into all these joint ventures were just starting. And in those days, they couldn't speak English properly. So my job was an unqualified legal advisor and interpreter and negotiator. But that was a great experience. So then I started the firm in 82. And at that time, the High Commissioner for India was Dr. Syed Mohammed, a brilliant, honest, clean man. He was Kerala's Advocate General. And he was, during Mrs. Gandhi's emergency, Minister for State for Law. And and that was my biggest lucky break. Because he saw a young Parsi boy of an Indian name, not trying to be anglicized. So he called me over and he said, he appointed me as the High Commission Solicitor. And I became the Indian government solicitor, knowing nobody in Delhi and straight. And he was so good that every afternoon, he would call me to come with the files. And he would sit with me. And in those days, luckily for me, India was going through a famine. And President Johnson it was absolute famine. And President Johnson had donated free wheat under PL 480 scheme. Okay. That means that India had to, the wheat will come free, but India had to charter ships. And India had, for 2 years, over 250 to 300 ships a year. And every ship had some sort of a dispute, late payment of freight, mileage, interest, compound interest, various other things. And it was a great experience for me. And I became a specialist maritime lawyer because I had a tremendous freedom with the support of Syed Mohammed And those days, India had a foreign exchange problem. So going to council and incurring fees in foreign exchange was not easy.
Right.
We had to get authority from Ministry of Law and Justice and Finance. So I used to appear myself, and that was a great experience. And so that's how I became a maritime lawyer. And I used to come to India very often at my own cost to collect evidence. Once I came to India, the Indian government team was very, very helpful, but they couldn't travel to England too. So it was a great experience for me. And in the 10 years, I must have said at least $50 million of claim against India in the shipping cases. And these are all reported cases. And I also, for the first time, we had India's first ever victory in the House of Lords in a commercial case called the La Pintada. That is a vessel called the La Pintada. And issue was whether compound interest has to be paid for late payment of debt. Okay. And the Indian government days were always late. They used to pay balance 10% after 1 year, demurrage after 3 years. So there was a test case, and that test case went to the House of Lords, and we won for India in the House of Lords, a case called La Pintada. And that was the first India's victory in the House of Lords. And this was in 82, 83. And that gave me a real shine in the legal field. And here's a young chap who took on everybody, and we won. And believe it or not, but my counsel for that case in the High Court was Tony Blair, who later on,
amazing.
Who later on went to become the Prime Minister. And he was led by Derry Irvine, who later on became his Lord Chancellor. See, Tony was looking for work. He was in the labor chambers. He just qualified. We were all very young. And the shipping was in those days considered a very sort of upmarket thing.
Right.
Upmarket people. But he was asking me for work. And his La Pintada case, everybody thought that it was a Denning judgment that if you pay late, you have to pay compound interest. And everybody's view was that that's a correct judgment. And I took a different view. That because you can't make a credit debtor an involuntary banker. And if you date, you can go to court. So Tony came to me for work, and I employed him as a barrister. And I also instructed his senior. He was very young then. But this is true. They agreed with me. But at the morning of the hearing, Tony Blair phones me up at 9 o'clock saying that Derry Irvine, who later on became Lord Irvine, wanted to meet me half an hour, 45 minutes before, but please come with the representative of the High Commissioner. Now, this is all fact, this is on record. So we went down there, and Derry and Tony said, there's absolutely no chance of success. This is such an uncommercial point. And I said, no. I told Mrs. Charawala, the High Commissioner legal advisor, I ignored the advice. I told him that, look, it was not easy for me to get instructions to brief counsel. And you told me that you'll argue my point, but they were totally unprepared. It came before Mr. Justice Stoughton, and he was so well prepared, and we won. The award was remitted. Wow. And that was the only time when I had to ask for an explanation from Tony Blair, and I sacked him. And later on, we went up to the House of Lords, and we won 5-0. So that was a case. But before that, I was also lucky. In the 82, there was a company called Global Shipping Dubai, which is part of the Al-Shirawi group, is still there. And they had a dispute concerning Jumeirah Beach Resort shipment. It's all shipping cases.
Right.
Arbitrator Cedric Bartlett transferred the hearing to New Orleans. And that was a great experience too, because it was quite a famous case. So these two cases gave me a very lucky break. And then fortunately for me, once I was appointed to the Indian government solicitor, we had lots and lots of work. Because in those days, there was no Delhi arbitration. All Indian contracts had English law and London arbitration. So that's how I got. I must have handled 700 national arbitrations. And so it was a great experience. And today, the firm has reached a situation where we are competing with the big firms. In fact, this morning, today or tomorrow, we start a claim for $1.7 billion Bank of England on behalf of the Venezuelan Central Bank. They had deposited, Venezuela has lots of gold production, and they had deposited gold safekeeping in the Bank of England, which is quite common. 4 years, they got a receipt contract, but now they want the gold back because of the COVID and everything to sell and to feed the people. And the governor of the Bank of England says, no, I'm not giving it back. The government and the government does not recognize your president on the grounds that he was elected by vote rigging and corruption. And my answer to that is so. If the Britain and United States could take the decision, then even India had ever allegation. Are you going to say that Prime Minister Modi is not the Prime Minister and I'm going to appoint?
Right.
You let the American a president from one of those councils. So there's an issue about that. So that's the thing. But we also did last year the biggest ever case in English history on behalf of Bank Malad of Iran against Her Majesty's government. Wow. And that was the clients came to me after they lost in the High Court and Court of Appeal. They had previously gone to a very big firm called Stephenson Harwood, and they were advised that Supreme Court no chance, so they came to me. And the issue was whether Bank Malad was involved in the Iranian nuclear proliferation. And the court said, let the sanctions remain. So the whole bank literally went out of business because it was an international bank. So we went to the court, Supreme Court, and we won 5-4. It is a big, very important issue. And the Supreme Court declared that the UK government had acted unlawfully and irrationally and sent the matter to claim damages. And we had a claim of 1.6 billion against HMD. And it was settled for a 9-figure sum, and it was paid. It settled settled on a day of the trial. So that's my background. I was a member of the International Court of Arbitration of the ICC, where I represented India. I had India's seat 8 years. And I was lucky at that time to have Fali Nariman as the vice chairman of the ICC Code. So that's it.
This just goes on to say that if one has determination, they can really achieve anything, you know. Come to think of it, with 60 pounds to what you've achieved today and all these fabulous claims, you know, working with such fancy people, all stars in the industry. So this really goes to say that if you have determination, you can really achieve anything. This is an amazing success story.
And the right values. Values are important.
Absolutely. Ethics and values.
Honesty and integrity is the key to success. Even though it may be slow, people will respect you. And the next is courtesy. There is no need to be rude. People, if you disagree, there's one good thing in England, that even in the courts, if you disagree, so long as you say things courteous, you can say the most horrible thing, but courteously, that's fine. No shouting.
Absolutely. I mean, I think it just comes with the business, because this line is such that you will sometimes have to be nasty, but if you're courteous enough.
No, that is not correct. It is absolutely untrue. Advocate has to be nasty. Advocate has to be totally untrue. And for me, the law is for justice and not justice for law. And in England, we don't be nasty at all. No shouting, no screaming. And honesty is the most important thing.
Well, that is just great. I mean, it warms my heart so much to hear the story, and the fact that you held on to the ethics and you still practice it with such honesty. This is
why people from all over the world, when Russia had an award for Yuko's case, which was a $50 billion award, which is still going on, they had gone to some very large firm, and after 5 years in international arbitration, they lost. It was an investment treaty arbitration.
Oh.
And all the law firms said, you can't challenge, you can't. So they came to me. People come to me for different cases. And I gave them a point of law, which I had tested it earlier, and they won.
Amazing.
First round. But they have lost, and now it is in the Dutch Supreme Court. I'm not involved because I'm not a Dutch lawyer, so I was just behind the scene. And that was, and the people don't know, but the Yuko's case was won by Russia in the first challenging the award on the grounds of an Indian case, where the English judge had to decide what was Indian law, and my witnesses would give evidence. Was Soli Sorabji, former Attorney General for PEC, which is an Indian government company, Indian-government-owned company, and the other side was Asia Golden Rice. Harish Salve was giving an expert opinion. And the point was a very technical point. After the arbitration was over, whether the contract which was signed by the PEC, a government company, was signed in accordance with the government rules applicable to government contract. Okay. And it is to two signature. And it was a very technical point, but Sorabji came and said yes, and Harish Salve said no, and the judge accepted Soli's opinion, and we won. So in the US, it was the same point. Although participated in the arbitration, the investment treaty was signed by the president of Russia, but it had to be approved by the Russian parliament, Duma, and that was not approved. So therefore, there was no contract, no treaty, and no arbitration. So let's see what happens. That's me.
Fingers crossed. I really hope that they win it and this goes in their favor.
Yep.
So, Mr. Zaiwalla, what do you consider as the three most important aspects of the business? Like, according to you, what are the three major aspects of the business?
The first major aspect of the business as a law business is that you must be sincere and honest first when you advise client, and not just give a fib to client if it's a good case. Even if it's a bad case, you have to be innovative. So the most important thing is getting it right. And you don't just, because the clients have come to you for justice. Second, the most important thing for me is an innovative approach. The firm has made a name for innovative approach to law. Today, there are 136 decided cases in the English International Law Report, but the law was made by Zaiwalla&Co.
Wow.
People come to me from all over the world, Russia, China. I acted for China for many years, and in my book, I have written the story with facts and figures.
That is amazing. Now we know who to reach out to for any law advice. This is really amazing.
Welcome.
So, of course, you mentioned honesty. Is there anything else that you would like to mention as important aspects of this business, especially like this industry?
In this business, you have to also get clients.
Right.
And therefore, good relationship is very important. Yeah. And I tell my young team, who are now sort of being very active in the firm, is that when you go at an event in marketing, you must recognize that when you meet somebody important who can be potentially client, you have to, within 2 minutes, have to qualify in the following terms. First, the person must like you. If he doesn't like you, you're out.
Yes.
Second, the 2 minutes through energy, or what you say, he must trust you. And third, he feels that you can deliver. Only if these three parameters are crossed, then you have a chance of continuing nurturing that potential client.
Absolutely.
So that's important.
Absolutely. I'm completely in sync with you. These three factors are really important when you want to gain clients. So
and to get work.
Absolutely.
Because there is now, when I started in England, I was compelled, because I was the only sort of Indian around in the city of London,
right.
The Indian businesses there would not come except Hindujas and one or two others. And they come to me. So I had to go all over the world to get work. And it was a great experience. And I got most of the work, not from India, because those days India didn't have any work. Yes. Because it only opened in 92, except the government work, which we did all the government work. But Dubai, Qatar, Saudi Arabia, and we a lot of arbitration, like the big New Orleans arbitration came from Dubai.
Well, I'm just curious, what prompted you to select international arbitration as your field? I mean, you've mentioned that you had that background running in your family, but why international arbitration?
It was by chance. I was training in a firm called Stockin & Company, which was an arbitration firm doing maritime arbitration. And after that, it was the High Commissions appointed me as government secretary. And there were in every year, there were 200 to 300 arbitration cases. Many of them were settled, but they used to all come to me. And so it gave me a tremendous experience in the international arbitration.
Amazing. And which has been your most memorable case, Mr. Zaiwalla?
In the international arbitration?
Yes, in international arbitration.
I think my most memorable and satisfying case it's my clients for Indian Oil Corporation from Delhi.
Okay.
And they were facing a claim of some 18 million or some $1 million, 8 or $18 million from a company called Coastal Bermuda. And this arbitration for about a week, Ince & Company solicitors representing Indian Oil, and they lost. And very badly they lost. There was an award against Indian Oil. But they were unhappy not because they lost, but because one of the arbitrators, there were 3 Queen's Counsel, and one of the arbitrators, Gordon Pollock, you see, very famous man, he passed away recently. He put a post note effectively saying that Indian Oil's legal team was incompetent. And if they had put it properly, the result might well have been different. And I'm going to read out from my book what Pollock said. I wish for India, it's against Indian Oil. I wish to record regret that the sellers, Indian Oil, had not at some stage broadened the scope of the case. The document gives rise to a strong indication that buyers intended to create a clear impression in the minds of the seller, blah, 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 blah. But effectively, he said that if they had a competent team, the result might well have been different. So Mr. Ramachandran, who later on became the chairman, he was the international and the team, said, Mr. Zaiwalla, please save us. We don't mind losing. But with this comment, our heads will be chopped in India. So they had got to 2 Queen's Counsel who said no chance because they had agreed not to challenge the arbitration award under the Arbitration Act 9. And then they came to me. So I made an application on a completely novel ground, saying that under English judicial under English public policy, if the court allows this judgment, this award to be converted to judgment with parties at the right, then the court would be in fact allowing to enforce a judgment which was not based on the true legal analysis of the evidence. Even the parties had made a mistake. And again, everybody said, oh, you can't argue that way. They had agreed. They can only challenge the award under one of the grounds for Arbitration Act. So we challenged. It came before Mr. Justice Evans, and we won. And this is a reported case. And the Justice Evans said that finality is a good thing, but justice is better.
Of course.
So our emblem is to come up with new innovative problems. Last week, if you read in the newspapers in India, we had a case which we succeeded against for 8 Indian defendants who were being sued by Punjab National Bank for $45 million loan, which they had not repaid back. And there was allegation of fraud and deception. Of course, every part came in and defended his own case. They came to us. We had the case struck off on a very technical ground that when the Punjab National Bank applied for a freezing injunction, you just freeze assets, they had not disclosed that they had made the same claim before a debt tribunal. So it went before the Court of Appeal everywhere, and it was struck off. Now, these are all innovative approach to law, because most people will say, oh, you can't do anything, you appeal law. Most lawyers will look at the law. And the law is for justice. You can play with the law, but not with the facts. Facts must be honest.
Absolutely. Facts have to be honest, and you constantly have to innovate. If you have to win cases, you have to innovate honestly and bring new sort of, I wouldn't even say evidence, but just bring a new perspective to the case apart from what's just written in the book. It's very important.
Fairness. And also, if you are honest and the judge believes you, and you build a reputation that if you're saying is true, and that is, we have today succeeded in about 85 to 90% of our cases because of reputation with the judges. That we would not mislead, we would be frank and honest. And okay, we will make some difficult law points, but that's for the judge to decide, not for me.
So Mr. Zaiwalla, as we're coming to the end of our time together right now, what would be your advice to our young legal professionals? Since you've been such a guiding beacon yourself in this industry, what would you like to tell them?
I think they must have silent courage because most young lawyers are too scared to take an innovative approach. So you must have a silent courage, and you must always be honest, straight, and with courtesy. And we must also have a marketing plan, because today it's a very competitive legal market. And it is important that they must know and feel their way around whether they're going to get client before starting their own. And to get client, you have to be both friendly and effective. So,
that is indeed great advice. And thank you so much, for sharing such great insights.
If you permit me to make one other point, and the biggest case which I had was a personal case, which was we were shipping lawyers, and every shipping has an legal fees insurance cover. And there was a company called Britannia P&I Protection, and they would refuse legal cover to my clients.
Oh, okay.
I went to the chairman, Mr. Patterson. He laughed. He said, "Oh, you're a good man. We'll see." Second time, SR, Ravi Ruya, instructed me for two of their ships. This is in the 90s. And I went and they instructed me, but they were also covered by the same insurance company. So they told SR, Captain Kumar, to withdraw instructions from me because I'm not approved. So I complained to the Commission for Racial Equality. And I did that in a proper way, not by shouting and screaming. If you read my book, there's a personal letter from John Major, the Prime Minister, saying that that's right, you must do that.
Would you like to show your book, the cover on camera for our viewers, please?
Certainly.
Well, thank you so much. So,
okay.
Viewers, this is the book by Mr. Zaiwalla. Thank you.
Thank you. Thank you for inviting me.
Of course, definitely. So again, thank you for sharing your insights. It was a pleasure having you with us for our session today. And for you and for our viewers, if you like this interview, if you want to know more about the industry, then you can definitely reach out to us on social media. This interview will be uploaded on all our channels, such as Clickaway Creators on YouTube. And of course, you can find it there. And this is Prachi for LexTalk.World.